Good afternoon and welcome back. I'm Marcus Peter. The Supreme Court has spoken in Chiles versus Salazar. The court ruled 8-1 in favor of Kaley Chiles. I'm talking with my friend Andrea Picciotti-Bayer, legal analyst for EWTN News and director of the Conscience Project. Once again, follow her work at conscience-project.org. Andrea, so great to connect with you again. How are you?
I'm doing great, and this is great news that we get to discuss.
We were just talking about this. It was a few weeks ago now, and you were prophetic, but sorry about that. But you were also very reasonable in pointing out that this Supreme Court has been doing a lot to draw us back to constitutional sanity. So, was this a surprising victory for you?
You know, after listening, Marcus, to the oral arguments in October, it wasn't a surprise. What was a surprise, though, is that the decision was 8-1, right? It wasn't along your traditional conservative liberal lines, but even, the two of the court's three liberals joined in, and I think that that's actually a sign that these are constitutional principles that don't have the same kind of partisan divisiveness, but really should bring us together. It's a unifying moment and a unifying case that protects children that are really struggling with issues related to their gender identity, their biological reality, their parents' decisions to reach out to Christian counselors, and the efforts of states like Colorado to muzzle those Christian counselors or counselors in general and only allow for affirming language. The Supreme Court said that just violates the First Amendment's free speech guarantee, and it comes at a really crucial time when we see gender ideology getting defeat after defeat after defeat.
Hopefully this signals, therefore, a grander, not just constitutional, but administrative return to at least natural law sanity as it pertains to maleness and femaleness.
I hope so. Obviously, Marcus, there's always going to be a fight for anything that's sinister, right? And although the two liberal judges, Justice Elena Kagan and Justice Sonia Sotomayor, joined the majority, they wrote a concurring opinion that really wasn't kind of dismantling gender ideology, but was more pro-free speech. But I think, when we think about how do you deal with falsehood, it's with truth. And so hopefully, especially when we're dealing with young people who are confused, more truth is going to be allowed into the therapist room, into the office, and that's going to help combat what has basically been, a web of lies that's being spun by ideologues on this very hurting generation.
So give us a few details about this case and help us understand the plight in this case of Kaley Chiles.
Yeah, no, this is not unique to Colorado. Colorado, along with, 23 other states in the District of Columbia, have put a ban on what they call conversion therapy, which may make you think about, shock therapy and that sort of thing. But in this case, it includes talk therapy, aimed to help a young person, and the ban is with regard to treatment for minors, a young person struggling with gender identity be able to embrace their biological reality. In Colorado, you could only talk in a way that would, quote unquote, affirm someone's gender identity exploration as opposed to their reality. So, this was a law that basically, puts duct tape over counselors' mouths, and although the case wasn't brought by patients or by parents, really does undermine parental rights and just individual freedoms because it only allows one outcome. Now, the Supreme Court said this is a regulation discriminates on the viewpoint of the speaker, so it allows speakers to affirm but doesn't allow speakers like Ms. Chiles to help someone grapple with their biological reality, and that it wasn't just a kind of benign attempt to regulate the mental health profession, but really was directed and targeted at compelling certain speech and banning other speech. Ms. Chiles, before this even went into effect, said this was going to subject her to, big fines and potentially losing her license. She, operated as she wished to operate. So, fortunately, she's vindicated. The case is going to go back to the lower courts, which is only interesting for lawyers. But the lawyers have been given a very good pathway by the Supreme Court, basically saying the most rigorous judicial scrutiny, that means looking at whether the state has met the highest bar possible in order to control the speech of Americans. So in many ways, I hope that this is a signal not only for the judges and the judge in Colorado, but for any judges hearing cases challenging these laws.
Can you please comment on the fact that, at least on the surface, this is clear viewpoint discrimination and therefore a violation of First Amendment rights? Yeah,
it's kind of crazy. It's like they didn't even try to hide it in the law. It says, you can help a young person if it's to further their gender identity, but you cannot if it's to basically help them come back to kind of a rational understanding of their biological reality. Doesn't matter that the child and the child's family wants some therapy that's consistent with their faith. Doesn't matter if they're seeking supports and accompaniment because confusion is hard, but they want to be at peace. It was only allowing one view to be shared in the therapist's office, and so that's just you can't describe it anything other than content regulation, viewpoint discrimination, and these are legal terms that courts have used to look at the regulation of government of speech. Our First Amendment has a free speech guarantee. There are very limited exceptions, and in general, when the government is going to regulate speech, it has to show it has to, cross a very high bar to do so.
Considering that, can you tell us a little bit about the thoughts of the dissenting Supreme Court judge?
Yeah, no, this is kind of crazy town, right? It's Justice Katanya Brown Jackson, who people may remember during her confirmation hearings was asked, can you define what a woman is? And she had a tough time coming up with a clear definition because it doesn't fit the progressive ideology that things are fluid, that there's nothing you can really hold on to. And she wrote a 44-page dissent, right? It's more verbose than the majority opinion and the concurring opinion written by her colleague, Justice Elena Kagan. And the majority was written by Justice Neil Gorsuch. And this opinion basically is, the idea that this is going to put young people in harm's way. This is basically going to be the end of a generation as we know it. And that kind of sky is falling rhetoric is just a repeat from what was said by lawyers representing the state and lawyers supporting the state, lawyers for the ACLU, which is, curiously enough, a group that was founded to protect free speech, but got on the other side of this case in defense of the state's restriction of free speech. So it seems like they've really kind of pivoted to being supporters of progressive ideologies. And it's telling, as I mentioned earlier, that her two more left-leaning colleagues really questioned the reasoning, just the legal reasoning that Justice Jackson put forward, saying that this is really not at all how the First Amendment should be analyzed. And I think it bodes well for moving forward and stopping these oppressive laws.
Well, Andrea, as usual, I greatly am appreciative of your insights, and we get to celebrate this.
It is. Amen. Thanks for having me on, Marcus.
Thank you, Andrea. My guest has been Andrea Picciotti-Bayer, legal analyst for EWTN News. We've been talking about how SCOTUS has defended a Christian counselor's right to confidentiality. Stay tuned. I'm Marcus Peter.